a year ago at Santa Clara University, when it was clear that there was a lot of confusion about what was taking place under the hood at internet companies. And much of that confusion was due to the internet companies themselves, who had not made it clear what they were doing. And so we had the opportunity to create a forum where we could exchange that information. And there was such interest in that exchange and so many things we didn't get to that it's wonderful to have a chance to continue the conversation today. I do want to extend my gratitude to both Tim and Gary for the work they've done, as well as the other co-organizers who have been a part of this process. These events, as you know, should look simple to you, but there were many, many calls, emails, and angst spent along the way to get us to here today. And so I'm super grateful for all the work that they did and for you guys for being a part of this. This event is not really about the commentary of what's going on. This event is really about trying to shake loose some of the facts and figures that help us understand what's taking place. But in order for the event to succeed, we wanted to make sure that everyone was on the same page in terms of the legal environment which the operations decisions are being made. So my goal for my remarks, before I hand it over to my co-panelist Tiffany, is to give you a basic legal foundation of the US law. Tiffany will talk about the international environment, and then the combination of the two should help inform the rest of the discussion about why companies are making the choices they're making or not. With that, I'm going to start by focusing on the US law. Those of you who are at the Santa Clara event, these slides have changed since February, and so we have new stuff to say even if you think you've heard it before. Many of you know the basics, and you're going to get 90% of the value in the first bullet point. And let me see, here we go. Whoa, that did not do what I expected. The first bullet says, online services aren't liable for third-party content. This is the basic framework of internet law here in the US. So we're going to talk about the exceptions. I've got 3 pages of exceptions coming up for you. So if you're wondering where's all the qualifications, got 3 more slides to explain all that. But the basic rule is websites aren't liable for third-party content. This rule is elegant, it's simple, and it has been enormously empowering for our industry. This is the rule that has enabled the growth of the modern internet as we know it. If you look at the top 10 most trafficked websites, I didn't pull today's stats, but 9 or 10 of them depend upon user-generated content, all of which has been enabled by Section 230C1. So this is the law of the internet in its most simple form and in its most powerful form. Now, let's make sure what we say. When I say websites or online services aren't liable for third-party content, most of the lawyers in the room says, oh, I can think of reasons why that's not true. So we're going to go through the mental exercise, all the things that you might think, well, let me think of those exceptions because I'm a smart person, I can intuit what the rule must say. Let me tell you what that might mean. Websites aren't liable for third-party content irrespective of their, quote, knowledge. We don't look to see what they knew or didn't know about the content that's on their service. That's irrelevant to the availability of this protection. So I put a but see FOSTA, because I'll have a slide on that in a bit. But for now, the starting premise is we've not had to ask who knew what when to determine whether or not a website could avoid liability for user-generated content. That's been enormously empowering because once you ask the question, who knew what when, lots of questions become very difficult to answer and lots of things start to go wrong. Section 230C1 says websites aren't liable for third-party content, and it does not depend on whether they were, quote, active or passive. There's no requirement that they be a passive conduit and unfortunately, some people in DC have said it's available only if you are a, quote, neutral public forum. That's just wrong. It doesn't matter about the website's neutrality or about their passivity. In fact, the whole point of the law is to enable services to make decisions about online content and actively moderate their services in order to screen out things that they might consider objectionable. This is the legal incentive that gives them the opportunity to do that without fearing that if they miss something, they're going to be liable for what they missed. So if you hear anyone say Section 230 turns on neutrality or turns on passivity, that's just wrong. Now, there are some qualifications. Those of you who are Section 230 enthusiasts know that there are some details I could explore there. But if you can get the basic point, the whole point of Section 230 is to enable active moderation of user content. That's the goal, and therefore it has to be available in those circumstances where someone's actually doing that. So the result is that internet companies can structure their content moderation operations here in the US however they want. They can do it where they have active moderation at the most robust level, or they could do it where they say, you know what, we're going to do the minimum possible. Anywhere in between those polar extremes, all the way to those polar extremes, equally protected by Section 230C1. Unless FOSTA changes that, we have a slide coming up. So some people have accused Section 230C1 of enabling online services to do nothing, to turn a blind eye. And there could be services that are built to turn a blind eye, and some services have tried to do that. Those services tend not to last very long. They tend to flame out quickly and get driven from the market. But services that are built to last, that want to actually create value, actually do far more than the law requires. They build their own internal policies and house rules about what content's permissible on their network, and then they enforce those rules. Now, they may not enforce it the same way that an offline publisher would have enforced it, because they don't have the same liability regime, and they might be trying to cater to different communities with different needs. But they are free to, and actually do, adopt more than the law requires them to do. Every service you're going to hear from today easily meets the standard and goes far beyond it. The last thing I want to say about Section 230C1 is it is a globally unique solution. As of today, no other country has followed in the US's footsteps. And that has given us as the United States a huge competitive advantage. This is an obvious correlation and perhaps causal reason why the internet lives here in the US. Why? Because we've created the legal infrastructure and foundation that enables user-generated content websites to flourish here. This is the reason why. This law right here is the explanation. There is a second part of Section 230 that I want to mention, Section 230C2, that provides a safe harbor for good faith content removals. So if a site chooses to remove content, the person who might be aggrieved by that removal is going to also be prohibited from suing. This doesn't get a lot of love for a number of good reasons, but the number one reason why is because it turns on a website's good faith, which means that it cannot usually be resolved on a motion to dismiss. It's going to require a summary judgment or a trial, which means it's not nearly as valuable to the internet companies because they have to spend a lot more money to even see if it's available. The other reason why is because removals generally don't trigger liability to the people whose content was removed. You can take content down per your terms of service and per other legal doctrines. There's no legal right to have content published on a particular site. So we just don't see a lot of action in C2. Notice, however, that Section 230C1, websites are liable for third-party content, does not have the same good faith requirement. And this is something that gets confused here in DC all the time. People say you cannot get Section 230C1 unless you engage in good faith behavior. That might be true as a real politic question, but that's not what the statute says. Okay, so all the haters of Section 230, it's your turn. Let's talk about the exceptions to Section 230. Okay, so there are 3 statutory exceptions plus the new one. There's a statutory exception for the ECPA or for state law equivalents. This is stuff like wiretapping. This is likely a null set. I've never been able to figure out why this is in the statute or what use case it applies to. So we're going to skip over this one. Okay. The next exclusion in the statute is for intellectual property claims. So the statute expressly says if it's an intellectual property claim, Section 230 doesn't apply. You notice here that I have 5 bullet points trying to explain that. So even that's not simple. So if it's a federal copyright claim, it's not covered by Section 230. However, Congress did enact a second provision, the DMCA's online safe harbor, that provides a notice and takedown scheme for copyright infringement based on user-generated content. So if users are uploading infringing files, the general system is supposed to be a notice and takedown scheme. For federal trademark, there is no statutory equivalent, but the common law has developed the rule, like the DMCA, that there's generally a notice and takedown expectation. If there's a notice that a user is committing trademark infringement, then the service is expected to take it down or face liability. With respect to user-committed trade secret violations, Congress passed a law recently, the Defend Trade Secret Act, that said that Section 230 applies to Defend Trade Secret Act claims. So if it is a federal trade secret claim, Section 230 still applies. you would say, isn't trade secrets an intellectual property claim? And I would have said, yes. Congress said the Defend Trade Secret Act is not an intellectual property law. Go figure. And then in the Ninth Circuit, which is the western part of the United States, the federal courts have held that where Congress said intellectual property, it meant only federal intellectual property claims. So state intellectual property violations committed by users are still covered by Section 230. So that includes things like publicity rights claims, state trade secret claims, state trademark claims, and anything else that might be a straight IP claim. If a user did it, Section 230 will apply to the Ninth Circuit. Outside the Ninth Circuit, but for a recent case, the courts have disagreed with the Ninth Circuit and said Section 230 doesn't apply. IP means federal or state IP. Okay, another exclusion in the statute is for federal criminal prosecutions. This has been on the books since the beginning, and one of the canards that we hear in our field is that Section 230 creates a lawless, no man's land zone, which I don't really understand what that means, no man's land. That's kind of the opposite, I think, but put that aside for a moment. That the idea is that Section 230 it creates a lawless zone on the internet where laws don't apply. This is just a gross misunderstanding of the statute. The statute says federal criminal law is not affected by Section 230 whatsoever, and it's said it since day one. This has been in the statute from day one. So federal criminal law has always applied, even in circumstances where Section 230 might otherwise apply. So some examples, online gambling ads. An online service that runs illegal online gambling ads will be potentially liable for federal criminal violations. The search engines about a decade ago settled that for close to $10 million. And then there was the allegations that Google was publishing illegal pharmaceutical ads. Google settled that one for $500 million. So let's just point out that where there's these federal criminal exceptions, there's a lot of money on the table, as well as the possibility of people going to jail. And of course, we know that people can go to jail because Backpage, the target of Congress's most recent effort, was prosecuted under laws that had nothing to do with Congress just did, under laws that were in effect from 1996, based on allegations that they enabled illegal prostitution. And that's an example where people will be going to jail for things that everyone thought here in DC was protected by Section 230. So when we say it's a lawless no man's land, what it really means is some people will be going to jail in these circumstances. One exception to this is that with respect to child pornography, Congress passed another law that said that there's mandatory reporting obligations. The online service, when it discovers user-submitted child pornography, must pick up the phone and call NCMEC. And then the last of the statutory exceptions is the new one, FOSTA, and I have another slide on that coming up. There's a long list of common law exceptions to Section 230. So these are judge-made interpretations of the statute. The most prominent one is the roommates.com case from a decade ago in the Ninth Circuit. The roommates.com case is a long, overly written opinion, and it has three holdings that are inconsistent with each other. So what I've done is I've given you each of the three holdings, and then courts interpreting the case are free to pick which of these three holdings they like. And so as you can imagine, the results have been somewhat inconsistent because when you write an opinion that's got three holdings, you're not going to get a consistent interpretation of it. Kind of like I tell my students, don't ever craft a contract where you have definitions of the same word twice that are not consistent with each other. You're not going to be able to select which definition is the right one if you have two. So the three holdings of roommates.com. One holding says, if you don't encourage illegal content or design your website to require users to input illegal content, you will be immune. This is the most popular holding. Roughly 2/3 to 75% of the cases citing roommates.com cite this holding, saying the only common law exceptions for roommates.com are if you encourage illegal content or if you do require, design your website to require users to input illegal content. A second holding from roommates.com is that a website can lose the Section 230 protection if they materially contribute to the alleged unlawfulness of user content. So if they contribute somehow to what the users are doing and that contribution makes the user's activity unlawful, then that contribution creates its own liability. An example of this would be changing a phrase that says, Tim Lorden is not a state illegal activity, and taking out the word not, so that the service makes the statement, Tim Lorden is engaged in legal activity. The third example is that says that Section 230 doesn't apply if the defendant is sufficiently involved with the design and operation of the systems that generate all this illegal activity. This is a very unpopular part of the holding, and I believe this particular holding has been mooted by subsequent case law. Okay, another exception to Section 230 is for false advertising. If a site makes a promise on its site that they're going to do something and then user content caused that promise to be untrue, arguably the site should be held accountable for what they said. Another case law exception is for promissory estoppel. If a site promises to a user that they're going to do something and then don't, if they have a claim for promissory estoppel, Section 230 won't apply. As those who've been to law school know, promissory estoppel never wins in court. This exception is almost irrelevant in practice. Similarly, we have an exception that says if a site failed to warn a user about some harm they might suffer because of the website, then that claim is not covered by Section 230. It is almost impossible for any user to win a failure to warn claim. So this exception, again, doesn't really help the plaintiffs. It just says, don't allege Section 230 as the defense, come up with something else. Okay, the last slide that I have here is about FOSTA. This is Congress's most recent innovation in Section 230 law. It is not a good innovation. And this slide is extraordinarily complicated, and this is my best attempt to try to distill down a statute that had at least a dozen different moving parts to it. FOSTA is the first time that Congress has substantively and materially diminished the scope of Section 230. The goal was Backpage, which had users submitted advertising for prostitution. Congress believed that some of those advertisements promoted sex trafficking, and Congress wanted Backpage gone. So in order to make sure the Backpage is gone, Congress did all the following things in Section 230. First, it created two new federal crimes. There's a new crime for the intent to promote or facilitate prostitution or conspire attempt, plus there's some enhancements for this. This is the 2421A crime. Now, this does not expressly reference Section 230 at all. How do we know what affects Section 230? Federal criminal claims are excluded from Section 230 by statute. Anytime you increase federal crime, it automatically covers new behavior that's not covered by Section 230. So Congress has created a new zone of regulation that Section 230 will not touch whatsoever. And when we talk about what does it mean to promote or facilitate prostitution, conspire, attempt, Congress is saying publishing third-party content could qualify as promoting, facilitating, conspiring, attempting to commit prostitution. So we're talking about publishing content being the things that would trigger the verbs in that sentence. In addition, Congress amended its existing federal sex trafficking statute, 1591, to say that it applies when the defendant knowingly assists, supports, or facilitates sex trafficking. This is a knowing standard. And this is exactly the kind of thing that I told you on the first slide we haven't had to ask in Section 230's history. Section 230's history has made the knowledge of the defendant in Section 230 cases irrelevant. This crime is not covered by Section 230. It never has been. Section 230 doesn't apply to federal crimes. Nevertheless, by expanding the scope of the crime to cover things that might include publishing third-party content, Congress has now said, what did you know about that content and when did you know it? Exactly questions that we didn't have to worry about before. In addition, Congress in 2015 had created the SAVE Act, which also applied to the reckless advertising of sex trafficking. I'm not sure what the center standard is on that based on some case law, but this was not Congress's first attempt at getting the same issue. There was already a law in the books in 2015 that covered the same ground. And we don't know what the First Amendment limits of these crimes are. We will probably find out. In addition to creating new crimes, Section 230 now expressly excludes state crimes that meet the following standards. A state crime that's coextensive with the federal sex trafficking claim, 1591, or that's coextensive with the new promotion or facilitation of prostitution crime, 2421A. So now, where state criminal prosecutions were covered by Section 230, Congress has created a zone where some of those crimes are now prosecutable under state law, and Section 230 will not be a defense to them. Now, to the extent that these mirror the existing federal crimes, or the new federal crimes, all this means is now we have a new set of enforcers. There's a new group of enforcers on the beat. We can ask the question whether or not it's a good or bad thing to take the DOJ and supplement them with dozens of state prosecutors who have different agendas than the federal government might have. And then Section 230 also now excludes certain civil claims. So this is a new exclusion for civil claims. And those civil claims apply when the defendant violates the federal sex trafficking crime 1591. So if the plaintiff in a civil claim can prove that the defendant violated the federal crime, the Section 230 will not apply. Now, one of the things, and I went back and forth with some of my other experts on this question, we think Section 230 still applies if there's a civil claim based on 2421A, the new crime about intent to promote or facilitate prostitution. So Section 230 will still apply to the other new crime, but one of the crimes now creates a civil cause of action that will not be covered by Section 230. Furthermore, FOSTA creates a new cause of action for state AGs to bring, and I am not an expert in Latin pronunciation, please help me out, let's say it all together, parens patriae claim for residents affected by sex trafficking. I don't understand the history behind this clause, I don't know what this covers, and I'm not sure what the state AGs are going to do with it. So you can see why FOSTA is a major change to Section 230 law. It opens up the door to the defendant's knowledge, something that we thought was not relevant in the past, and it creates a bunch of new enforcers on the beat, and it creates a bunch of ambiguous questions about what exactly is Congress doing. And the most important question is, does this actually help sex trafficking victims? We know that this law was not required to resolve the Backpage situation. How do we know it? Because Backpage and its CEO had pleaded guilty before this law was even signed into law. So I think I've exceeded my 15 minutes of time, and so I think I've done enough damage here. I'm going to turn my control of the slides over to my co-panelist, Tiffany Li. I want to thank you again for coming today. This is such an important conversation. Having you all part of it means a ton to me. Thank you.
Hi, everyone. So Eric obviously needs no introduction, but I will introduce myself. I'm Tiffany Li, and I am a resident fellow at Yale Law School's Information Society project. There, I direct the Wikimedia and Yale Law School Initiative on Intermediaries and Information. I am also an Internet Law and Policy Foundry Fellow. So we looked at intermediary liability already from the US perspective, but I think it's necessary to look at a global perspective because as we all know here, the Internet has no borders, so platform companies have to look at the laws of pretty much every country. Here's how I think about this generally. When you look at intermediary liability from a global perspective, you have a few basic issues. First of all, as Eric already mentioned, the United States is relatively unique in having a strong intermediary liability framework. This is not the case in many countries around the world. In many countries, there aren't even laws about the Internet specifically, not to mention specifically intermediary liability protection of Internet companies. Instead, many governments regulate or attempt to regulate Internet companies through various areas of law, including defamation, intellectual property, speech and expression, and privacy. What's also key is realizing that legal issues outside of regulatory content issues are also important here. So I think of jurisdiction, competition, and trade as legal issues that are necessary for people to understand when thinking of content moderation, because these legal issues apply to how companies have to think about complying with these international regulations. Generally, broadly speaking, many countries around the world are trying to regulate the same set of problems. These problems include extremist content, hate speech, child protection, privacy, and everyone's favorite, fake news. Of course, by fake news, I mean media manipulation and political manipulation. So we start with the EU because, as I think everyone here knows, the EU is a leader in the tech policy space. And by leader, I don't mean necessarily the best or most correct, but the region that creates possibly the most laws on internet regulation. The first thing to think about is the speech norms. Now, much has been said about how the EU and the US have very different norms on free speech and free expression, and this is true. They don't have the same First Amendment traditions that we have here. Instead, they have what some would argue is a much stronger human rights law regime. I think it's necessary to take a step back, though, and realize that though we may have different norms on speech and expression, there are still more commonalities than differences when looking at the US and the EU, especially when compared to regulations from around the world. But in the EU, we do have many very strong human rights laws, including ECHR Article 10, which creates a right to freedom of expression and specifically includes the right to receive and impart information without interference from public authority. Now, this interference can include geo-blocking, filtering, content takedowns, and so on. So this is an important article to understand for intermediary liability. Generally speaking, though, in the EU, when you have difficult conversations about intermediary liability and free speech, many different human rights will often trump free speech. So if you have, for example, a clash between privacy and free expression, often the privacy rights will prevail, which is not so much the case in the US. We have, for example, in the EU, the right to be forgotten, which is the right for individuals to request that information about them be taken down or erased from public content. Also in the EU, we often find much stronger defamation laws than we have in the US, which again goes towards the same theme, which is generally that freedom of expression is protected in a different way in the EU than it is in the US. And finally, I have to mention that one issue many people discuss when talking about EU regulation of intermediary liability, or just internet in general, is the concept of jurisdictional reach. Now, many critics of EU regulation argue that the EU, in trying to regulate internet companies, sometimes exceeds its jurisdictional approach by trying to regulate much of the rest of the world through its regulation of internet companies. Now, whether or not this is true depends on what you believe in terms of who should be able to regulate the internet. But here are some of those regulations. First, we have the e-commerce directive, which is established in the EU and applies towards the entire EU and is implemented differently in different nations. Here, there's no notice and takedown process, but there is generally a provision that says platforms can't have general monitoring obligations. There's also a draft copyright directive that includes appropriate and proportional measures to prevent copyright infringement. Additionally, we have the GDPR, which is the General Data Protection Regulation, a broad privacy regulation that also impacts freedom of speech and content on tech platforms. This will come into effect on May 25th, and many of you who are working in companies have already been dealing with this for quite some time. Additionally, in the EU, we have the Terrorism Directive, which has a similar approach as the material support to terrorism provisions we have in the US. There's also the EU Security Agenda with a Hate Speech Code of Conduct. And in Germany, we have the NetzDG. So when we look at hate speech in the EU, we have to take another step back and think again about the differences in freedom of speech and understanding speech generally. Hate speech is understood in very different ways in the EU than in the US. Now, the Germany law, NetzDG, has been particularly controversial because it criminalizes a form of speech that is very difficult for United States companies to understand. Specifically, there are very strict restrictions on what type of speech has to be taken down. These types of speech are, quote, obviously illegal, which is not really a great standard. The law also includes strong, very high fines and a very short notice and takedown period. So these are some of the laws and regulations we're seeing coming out of the EU right now. In the UK specifically, because remember the UK may no longer be part of the EU, we have the Digital Economy Act of 2017, which creates a statutory requirement for ISPs to block access to websites not complicit with rules on age verification for sexually explicit material. We also have current proposed changes to the Audiovisual Media Services Directive, which is very similar to what we have in the US under ADA and FCC protections for disability rights, think closed captioning and so on. In the UK, defamation law is particularly strong, especially when compared to defamation law in the United States. Very recently, we just had a new case, Martin Lewis versus Facebook. I believe this was this March, in which someone is suing Facebook for false advertisements that involve his name or image. Now, moving across the world, we go to Latin America, where we have a very different human rights framework. Now, in the Latin America sector generally, first, let me make a caveat that I'm speaking very broadly, and there are many exceptions. This is all very general. But generally, we see many human rights and free expression laws in many of the nations in Latin America, including the Inter-American human rights system. We've also seen a number of interesting cases come out of this region, including in Argentina, the Maria Belén Rodriguez versus Google case, in which a model sued to take down certain content that was depicting her. In Brazil, we also have the civil rights framework of internet, the Marco Civil da Internet, which is most likely not how it's pronounced. But generally speaking, we do see these interesting cases, and we see interesting regulations coming out of Latin America that I would argue are actually very innovative when looking at intermediary liability on a global scale. However, we also see many legislative threats coming. We have different politicians, different governments arguing that there should be more restrictions on intermediaries, especially intermediary companies that allow for social media content to proliferate. And much of this, again, links back to the entire fake news discussion and the political pressures that many of these governments may either be facing or may be putting onto their own citizens in context of that. When we look at Asia, there is, I would argue, probably less law, generally speaking, on intermediary liability, not less law in general. But if we look at a few specific cases, again, this is obviously not all of Asia. There are more than 2 countries in Asia. But in India, we have solid case precedent on intermediary liability, or at least on internet and speech issues generally. And part of this may be a biased opinion coming from American scholars, because India does have a constitutional law system that's very understandable for us. But we look at cases including Shreya Singhal versus the Union of India, which established that certain restrictions on intermediaries and internet websites could be in violation of freedom of speech laws. So this, for intermediary companies based in the US, is a very positive case precedent. In China, we have a sort of very new developing law or new developing legal system regarding the internet. We have a draft e-commerce law that tries to put into place certain copyright provisions specifically, but also some privacy provisions that are interesting, including something that is a little similar to the right to be forgotten. Now, the right to be forgotten generally is usually a matter of privacy law, not a matter of speech law, but it of course implicates content takedowns and content moderation. So anywhere we see the right to be forgotten popping up, this is something that tech companies, especially tech companies that have personal information, these companies need to look into very strongly. Another trend we're seeing in Asia particularly is the trend of trying to regulate fake news. Now, I've mentioned this a few times already today, but I think it's important that we look at this question not just as a political question, but as a legal one. For example, Malaysia recently passed a fake news law, and they, I believe, have actually had their first case based on this law very recently, just this year. Similarly, in India, there was a proposal to create a fake news law, but that proposal was shut down fairly quickly. In Singapore, there's a similar proposal to, again, also create a law that would criminalize fake news. In the recent hearings in Singapore, on the recent Facebook hearings in Singapore, Mark Zuckerberg and his company were asked, or not Mark Zuckerberg because he did not appear, but his representative was asked about specific questions about fake news and media manipulation. These issues are front and center in much of the legal debates that we see right now, not just in Asia, but in Latin America and in Europe. This is important to understand because sometimes fake news can be used as somewhat of an excuse for governments to create new laws restricting intermediaries and restricting free speech. So we think of fake news, we think of these new legislative opportunities, but we also look at the risks to tech companies. Fake news is, again, one of the global political pressures that we have to look into. But more global political pressures that might be changing the way intermediary liability is understood in different countries include privacy, competition, and trade. These are all areas that I think are very important for tech companies to research heavily and invest in heavily when looking at the tech policy space, not just in terms of intermediary liability, but in terms of intermediary rights and intermediary responsibilities. And for privacy, we have the GDPR in the EU, but we have similar pressures around the world, especially in context of recent scandals like Facebook Cambridge Analytica or all the various different privacy exposés that have come out in the past few years. Obviously, we know here at this conference, I think most of you would understand that privacy is very difficult to deal with, just as content moderation is incredibly difficult to deal with. However, as a political subject, privacy is very easy for governments to use as an excuse for new regulations. So taking care of privacy is important in order to make sure we have good regulations on content moderation. Similarly, we can't discount the pressures of competition and trade law when discussing intermediary liability regimes in other countries. Most of the internet industry right now, at least the internet industry related to intermediaries, is based in the United States. So competition and trade law are very important in understanding how intermediary liability might develop in other countries who may be trying to protect their own interests, either their corporate interests or the interests of their citizens who may be believing different speech norms or different norms on privacy and so on. And of course, generally, when you think of all of these different political pressures, you have to think about what is the role of intermediaries. How should intermediaries navigate conflicting laws and standards for compliance? If you are an internet company in this day and age, you have to, more or less, comply with the laws of every single nation around the world. This is extremely difficult because many of these laws conflict. Throughout this day, I'm sure we'll hear from many experts about how this can be done and how we can navigate competing laws in a way that doesn't stop innovation, but allows the internet to flourish and also to protect the freedom of expression that we love so much from the internet. We also have to think about what responsibilities intermediaries might have for speech, for privacy, for intellectual property protection, for fake news again, for public safety, extremist content, and child protection. These are all issues that are front and center for many people and many policymakers specifically. So tech companies have to recognize this and make changes in order to make sure that, again, regulations about the internet or regulations on intermediary liability proceed in a positive manner. What's underpinning a lot of discussions about international intermediary liability is, I think, these final few questions. Should any one country be able to regulate the entire internet or the entire world? The jurisdictional concerns, I think, are very serious and important to at least research or discuss. Some would argue that the US tech industry is actually exporting US values like free speech. There are many countries in the world right now where free speech is not viewed as a human right and is not protected by the government. Some would argue then that the US is exporting our values by allowing for free speech to foster in an online environment. On the other hand, can or should intermediaries protect these exact rights, the rights like free speech and free expression? Should these intermediaries be protecting these rights, and what responsibilities do companies have to promote these rights worldwide? These are a few of the things I think about when navigating intermediary liability globally.